I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So court is calling 2023 CR 8806, State of Texas versus Christopher Scott Jones. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
David McLean for the defense.
And are you Christopher Scott Jones?
Sure.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christopher Scott Jones who was placed on deferred adjudication in 2023 CR 8806 for the offense of assault, family second offense on November 28, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Your Honor, on or about the 21st day of March, 2024, in Ventura County, Texas, the defendant, Christopher Scott Jones, did then and there contact Scarlett Jones in person in violation of condition number 19.
How do you plead to that? True or not true?
True. And then, Your Honor, the state will waive and abandon the others.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19? Court will find violation of condition number 19 true. The court will let both parties know. The court has received these documents in the court's file. I have not read them because I don't read anything until both parties have had a chance to view them and have any objections to them.
Absolutely, Your Honor.
So have you all both had a chance to review the documents that are sent to the court's file?
I have not, Your Honor.
Those are the ones from last year.
Okay, those are the ones we talked about last time.
That's exactly right. Yeah,
Okay.
there's nothing new. Those are from, nothing from the past like week or two, correct, Your Honor? Those
No.
are no, so yes, I believe counsel and I have reviewed them in depth, all of them together.
All right, and would you like the court to read these, counsel, or do you have objections?
Essentially, Judge, they're hearsay, but I know the court can consider that.
Well, I mean, if you all have objections to it, then I won't read them. They are hearsay.
I'd object. Judge.
All right. All right, so if the witnesses are not here for the court to read those, then the objection will be sustained.
Thank you.
All right. So is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance, house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in VIP within 15 days of release.
All right, and who is Scarlett Jones and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated within the.
Everyone, please whisper.
I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right, is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
Okay,
Same person, Judge.
all right, same person. So I ordered,
No, Scarlett Jones is my wife, Ruby.
Okay. Scarlett Jones is Mr. Jones' wife.
all right, and who is Sydney Jones?
My daughter.
All right, and Scarlett Jones, okay. The court ordered no contact with Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The council may know.
Yes,
Ruby, who is that?
no, Scarlett Jones is the person he pled true to the number 19 violation,
Yes,
and I ordered no contact with that person. So
understood.
I
Okay.
want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced. We have new paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding was, is that he had gone by, and he is struggling mentally to try to let go of what this relationship was. He misses his kids, he misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an excuse me, an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he?
Who?
How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right, so I don't understand what he doesn't understand, that the court ordered a no contact order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I totally respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse,
Mhm.
but I think that's the reality of what happened.
Mhm.
Nobody was harmed. Nobody was, I don't believe in, nothing happened from the contact. I'm trying to get this guy back on track.
But this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense, and we probably wouldn't be here, and maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for what, about 60 days now? He's gonna have another 30 on house arrest. He's gonna be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth, and that if he violates that, it's not just an MTR next time. He's gonna be back in here on a violation of a protective order.
Oh, but my rulings have teeth, and my ruling was
Absolutely.
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger
I
management?
enrolled in the PIP. I did 5 classes of PIP so far.
Probation, has he done anything?
Judge, he was granted probation in November. He submitted a negative delay in December. I don't have any indication that any of his classes have been complete. He did pay a total of $190 for his assessed fines and fees.
All right. Is there anything else?
No, Your Honor, and if the court would like to as well, like I said, not a state's file, like me creating a separate thing in a different file chart. I had to draft out the relationships. It's like a whole page of who interacts with who. So if the court, if I could better explain, I would. I have that information. I don't have it with me. It wasn't.
Oh, no problem. The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. he probably would still be in a relationship with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful in this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. Explain it to him, and if he comes back.
All right, the court is finding violation of condition number 19 true. The court is going to find him guilty. There's an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish to speak to punishment?
Your Honor, I understand the court's ruling. I think that given the facts and circumstances here, and the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family. And I don't see him going by there at all. We would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this. Be a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just asked the court to consider this the minimum on this case.
State.
And then, Your Honor, the state, about 10 seconds, Your Honor, the state is accessing the legacy system just to get a better handle on the Bear County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor, and that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding of family violence, give you credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and signed it?
Yes, ma'am.
All right, do you have a limited right to appeal? And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I want you to know, I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Good luck to you. Court is calling 2024 CR 0348 and 2024 CR 1860, State of Texas versus Macedonio Martinez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Scott McCrum from Mr. Martinez.
Are you Mr. Martinez?
Yes, Your Honor.
Counsel, have you received all of the discovery in each cause number, and did you review it with your client?
I haven't, I did.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the documents entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, sir.
And did you sign it?
Yes, Your Honor.
And each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Judge.
State, in each cause number, are you proceeding on the indictment as presented? Did you review the documents entitled Court Admonishments and Defendants Waivers of Affidavit and Admonitions with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, sir.
Did you understand, and the cause number ending in 48, you're charged with the offense of assault, family choking, strangulation? That's the third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison. and up to a $10,000 fine. And the cause number ending in 60, you're charged in counts 1 and count 2 with cruelty to non-livestock. Did you understand that is also, cruelty to non-livestock, torture, etc. Did you understand that each of those cause numbers, in each of those counts, the range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes,
If
Your Honor.
y'all will put count 2 on both of those, counts 1 and count 2?
Yes, Your Honor. Would you like me to put it just after the 94 or?
No, if you'll put it after the charge or either above the charge, that way he'll know it's count, yes, he'll know it's count 1 and count 2.
Absolutely, Judge.
Do you need a break? Okay. And each cause number, do you understand you have a right to jury trial? Oh, I'm so sorry. Do you have the cough drop now? All right.
It gives me time.
Let me see if I have one. I think I mentioned some. Do you have any cough drops over
They're
there?
down there, Judge.
She was-
And that one.
okay.
All right, just one moment. Let me grab a cough drop for her.
She might have flower allergies.
All right, we're back on the record. And did you understand, if you have a plea bargain agreement, the court does not have to follow your plea in either of these cases. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Counsel, did you have him sign? Did you understand by entering these agreements, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offenses?
I do believe.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, punishment is to be assessed at 8 years in the prison. The state recommends community supervision. The cases will run concurrent. State will take in consideration 717-751, 723-910. There's to be no ownership of connection with animals or pets. And in the cause number ending in 48, there's an affirmative finding of family violence. There's to be no contact with the complainant and no contact with Dominique Hernandez. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent? Did you understand that to be your plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Only bond-related motions, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. And the cause number ending in 1860, they're requesting a TAP evaluation, follow recommendation, $1,000 fine, 200 hours of community service restitution, and that you be placed on the MIC caseload. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in the cause number ending in 1860, how do you plead to count 1?
No contest.
How do you plead to count 2?
No contest.
And the cause number ending in 0348, how do you plead?
No contest.
State any evidence.
Yes, Your Honor. For both causes,
State, did you have a chance to speak with the complainant?
yes,
And is the complainant aware of the plea agreement?
the complainant is aware, Your Honor. Yes.
All right. You may be excused.
Thank you, Judge.
And each of the cause numbers, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And cause number ending in 0348, the court will find you guilty. And the cause number ending in 1860, the court will find there's sufficient evidence to find you guilty of count 1 and count 2. The court will find you guilty of count 1 and count 2. Is there anything you wish to say on behalf of your client?
Just so you know, Judge, he was going through mental health issues when this occurred and was off his medication. Since then, he's been on a GPS and has on his own gone and had an anger management class that he completed. More importantly, I think, is he is consistently seeing a therapist that can be verified with his pretrial officer because she's allowed him to go to the appointments, and also got back on his medication with the doctor. So he's addressing his mental health issues. And so I'm confident that you won't have any issues with him on probation. He's also gonna suffer a severe consequence already out of this, even though he's getting probation, and that he's been a licensed insurance adjuster for, I think, going on 20 years. Because of these felony convictions, he's gonna lose his license and lose his job. He's confident he can find other work, but he would have preferred not losing these things. So he has suffered consequences because of this, and he's addressing the mental health issues that caused it, if that'll give the court any comfort in this video.
Is Child Protective Services involved in this?
No, they're divorced and they're not his biological children.
Okay. Well, why
He
was
does have his own children though.
Well, in the police report, he's complaining that she has a boyfriend at the child exchange. So what child exchange was taking place?
I don't know, but if it's something that you saw from the police report of that incident, like I said, his mental health wasn't right, but maybe you can answer that.
We never had, the only child exchanges we had were with her ex-husband. And that's how we would do child exchanges. Like I would take them.
No, I mean, your attorney is saying that you don't have any biological children with her.
Oh, no, we're not with her.
What he's
Alright.
saying is he would take the children to meet with their father.
Their stepchildren, my
Child
stepchildren.
But they're divorced, so he doesn't have contact with them anymore.
And what is his mental diagnosis?
Anxiety and depression. But I've kept up, I've started off at twice a week for therapy, once a month for psychiatry. And they've tapered me off to once a month for therapy, and then once a month for psychiatry.
Okay, I'm not a psychiatrist. I don't pretend to be one. Did I take a lot of psychology courses in college? Yes. Where I could have majored in it? Yes, but I'm not a psychiatrist. So I don't understand how I'm not on my anxiety or depression medication equals cruelty to animals.
I don't know, Judge.
So if I can explain that, Your Honor?
Yes.
So on that day, it was a long week. I underestimated my role in the situation where her daughter, my stepdaughter at the time, had a back surgery. And so I thought it was going to be, her and her ex-husband or whatever. So he didn't go. He went for like 2 hours. And so I took the whole week off of work. That was stressing me out. And then when we got back from when she was released from the hospital, I had to go pick up my mom because it was my daughter's time to come live with me for the summer because of my agreements. So I drove back from Laredo, came back, and then we went to the hospital, picked up my stepdaughter, and we all went home together. And then we just started to have an argument, and I think both of us were really heated. Then when she left me, I fell asleep because we fought all night and I worked all day and I passed out. I fell asleep. When I woke up, she was gone. And I had lost my family, and so yeah, I just, I, kind of I've never had a mental health issue like that, like a mental lapse like that.
So I'm trying to understand how all of those pressures translate to killing a rabbit, and it appears snatching apart the spine of a snake, but you didn't disturb the cats that were your mom's cats. So I don't understand.
Oh.
Who did the snake and the rabbit belong
Cats are
to?
the cats are all of our cats.
All right, so who does the snake and rabbit belong to?
The rabbit was mine and hers, and the snake was her son's.
All right, so you killed the rabbit and you killed the snake. All right, this is what the court is ordering, and cause number ending in 0348. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. This will run concurrent with 2024 CR 1860. Taking consideration 71775, 723910. There's an affirmative finding of family violence. There's to be no contact with Christine Martinez, Dominique Hernandez, no unsupervised contact with minors, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home healthcare provider or with minors. There's to be no ownership or contact with any animals. So that means not going to the zoo, anything that has to do anything with animals. You can't own a goldfish, anything. You understand? I'm going to want field visits 1 time per month until further notice. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, that will be deemed satisfied. Is there anything else with regards to that case, probation? Did you? There'll be regular random UAs. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in that cause number? Did you understand it and did you sign it?
Yes, yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because it's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, yeah.
All right, next we're going to proceed in cause number ending in 1860. In each count, the court is finding you guilty. Both counts will run concurrent with each other. And it will be concurrent with 2024 CR 0348. Regular reporting by Zoom or in person. Regular random UAs. 200 hours of community service restitution. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits until further notice. No unsupervised contact with minors. There's to be a TAP evaluation, follow all results. There's to be a MIC evaluation, follow all results. And those evaluations are to take place in custody. There's to be no contact with animals. Probation, there's going to be field visits until further notice. Is there anything else he needs?
In filling out his personal data form, it indicates he lives in Laredo.
Okay.
So are you giving him permission to?
All right. So what we'll do, because you all can't do field visits in Laredo, correct?
So we can transfer the case. We can transfer the case, and depending on whether or not they have the ability to do that there, I can ask for a report to let you know.
All right, so we'll do a transfer to Laredo. I'm gonna want GPS, waive fees, and he's to be on GPS until further notice. Is there anything else probation?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And probation, both cases, you can see if they'll transfer them to Laredo. All right, thank you. Deputy Laura, he's gonna go into custody. All right,
Judges, are you ordering jail time as a condition of
I'm-
probation or what?
I'm ordering that he remain in custody until the TAP evaluation is completed, until the MIC evaluation is completed, and follow all results of the TAP evaluation and MIC evaluation.
He's still got a job at this time, Judge. I mean, could you give him a week to turn himself in or something to make those arrangements with his employer? And
No,
that's gonna hurt his livelihood.
I mean, I understand. All right, thank you. All right, court is calling NYMAG number 749826, State of Texas versus John Harold Robinson. Can I have parties announced for the record for the state? Defense?
George Sherman on behalf of the defendant.
And are you John Robinson? All right, the court has received a first violation report for high brack readings. Defense?
Judge, I'd just like to bring something to your attention. You've probably noticed it already.
Mhm.
The arrest date was in February. They generally give him 30 days to get an ignition interlock, which he did.
Mhm.
And all of these violations are in the first month of his ignition interlock. And my position for this, and you can talk to him about this, it's a lifestyle change for somebody here. And I understand there's no excuse for this, but he is not drinking now. And you will not see him here again on a violation.
All right, state?
State's position is that there seems like high bracks over a period of time. And that's just concerning to the state. Other than that, we'll leave it to the court with any type of comments or additional bond conditions.
All right, this is what the court is gonna order. There's gonna be continued no alcohol use. The ignition interlock is gonna continue. You're gonna do the DUI, DWI education course. And I'm gonna want 90 sober meetings from you in 90 days. Do you understand?
Yes, Your Honor.
Are you currently doing any sober support meetings?
Yes, Your Honor.
How often are you doing them?
2 to 3 times a week.
Okay, that is awesome. But you're gonna need to do the 90 in 90 days, you understand?
Yes, Your Honor.
And that'll start from now. I'm glad you understand what it takes for you to be sober. All right, is there anything else?
Nothing for the defense.
All right, thank you.
Thank you.
All right, if there's an issue with your sobriety and you feel as though you need more to address that, all you need to do is come back to court. Don't let me get a violation report, you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, everyone, we're recessing at noon. So if you are not ready, then what's going to end up happening is you're going to be brought back in the afternoon. Joshua Wong? Hello. Hi. So where are we on this case?
We've conferred, Judge, and we're hoping to reach a resolution, but it's something that the state has to seek approval for.
All right. State is July 15th. Is that enough time?
Yeah, I'm sorry, I was trying to think about what today was, but
Yes.
that's about over 30 days, so
Yes.
yes, Your Honor.
All right, thank you.
Thank you, Judge.
I'll give you the reset form, then he'll be excused.
Very good, thank you.
All right, thank you.
The bailiff says. I
All
haven't
right,
seen it.
court is, you're on this side.
Oh,
Court is calling 2024 CR 5005, State of Texas versus Jose Luis Parra. Can I have parties announced for the record for the state?
Tucked on for the state.
Brenda
Defense?
Levenstein for Mr. Potta.
All right, this hearing was scheduled at 9 a.m. It is now 11:18 a.m. Defendant has not answered the docket. Counsel, do you know where your client is?
I do not.
All right, to the clerk, can you check to see if he is on a commercial bond or not? And Deputy Laura, was there an announcement made for Jose Luis Parra?
I did, there was no answer, Judge.
All right, and defense, have you attempted to contact your client?
Yes, and I did make contact with him, May 7th. That I reminded him in ed court today.
All right, state,
The state would respectfully request a bond forfeiture, Your Honor.
all right, and to the clerk, is he on a PR bond? Thank you. Court will grant the bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider.
All right, thank you.
You're welcome. All right, what's happening with this case? Where are we in discovery?
Judge, there are two different cases. There's a family violence case, which is following the drug case. The family violence case just is not as good a case. The drug case deals with drugs that were found in custody.
All right, so where are we on discovery? Do you have all the discovery?
I'm about to explain to the court. That was that background. I don't have any video cameras of the area that the drugs were supposedly found in. My client told me, and I'm embarrassed that I didn't think about it, that there are video cameras. Since I didn't raise that with the state until today, it's difficult for me to complain to the state that, hey, you didn't get that for me. So what I'm asking for is, I do need that discovery. My plan was to subpoena the Bexar County sheriffs for that. I truly do not know if there are video cameras of the holding cells. I just don't know because I've never dealt with it before.
They are, but sometimes they're not working and sometimes they're not in the location that you think they are or should be. State, do you have any idea if there was video?
Judge, at this current time, no, I haven't had a chance to really dive deep into the case. The defense did bring this up to our attention this morning.
All right, and did you tender an offer?
I think a previous offer had been given in connection with the other case, but I think in light of the fact that this new information was presented, I think the defense wanted us to consider that.
All right, we're coming back on June 15th. On June 15th, y'all will either have video or not have video. If you do not, then someone will need to file a motion, and then from there, there'll be a quick turnaround for a plea deadline date.
You said June 15th, is that?
That's Monday. Can
Judge,
I
I'm not
have a
trying-
reset form, please?
Judge, I'm not trying, or June 15th is.
I'm sorry, not June 15th, July 15th.
Okay. Judge, I'm scheduled to be at the Mayo Clinic from the 15th to the 17th for my asthma. Could I come back the week before, or the week after?
All right, I'll put it on the 22nd.
Thank you very much, Judge. I appreciate it.
So that'll be July 22nd.
Judge, I do appreciate it. Thank you.
You're welcome.
Is Miss Weaver excused
No, she needs to sign a reset form.
after she signs the reset form? Is she?
Yes.